let me go ahead and enable this. Give me 1 second. All right, you may proceed.
Your Honor, a bill of review proceeding is a equitable one designed to prevent a manifest injustice. And I think when the court hears the evidence here today, they are going to see that this case and this circumstance is absolutely the result of a manifest injustice that requires correction. Importantly, the plaintiff, as the bill of review plaintiff, Mr. Patel bears the burden of proving that there was no service. However, because a bill of review constitutes an attack on a judgment, there is no presumption that applies in favor of the valid issuance, service, or return of citation. Now, ordinarily, there are 3 elements of a bill of review. One is that there is a meritorious defense to the underlying cause of action. 2, that the plaintiff was prevented from making that meritorious defense by the fraud, accident, or wrongful act of the opposing party. And 3, this scenario is really unmixed with any fault or negligence of the bill of review plaintiff, or in this case, Mr. Patel. With regard to the meritorious defense, it's merely a prima facie showing of a meritorious defense, meaning that the defense is not barred as a matter of law, and that at a retrial, if there was no evidence to the contrary that presented, that the meritorious defense would be enough to entitle the bill of review plaintiff to judgment at a retrial. It's not really a full-blown merits of the case just because the other side presents evidence that would, at this hearing, for example, that would attack the meritorious defense. That really doesn't matter. It's a prima facie showing. All that matters is that it's not barred by law, and that defense, if unopposed at a retrial, would be enough to entitle the bill of review plaintiff to judgment. I think we were getting to this before a little earlier, Your Honor, but if a bill of review plaintiff proves non-service, then the plaintiff does not need to present a meritorious defense or evidence of fraud, accident, or mistake. So I know that we are going to proceed, I guess, the first phase of this on that question of whether there was proper service or not. Now, the standards we just talked about for a bill of review, those are the Hagendorf standards. However, if the court did rule that there was proper service of the underlying lawsuit and petition, there is a unique scenario at play where the Craddock standard for a motion for new trial can apply to a bill of review proceeding when a plaintiff is unable to file a motion for new trial because of an official mistake. Now, what this looks like and what a plaintiff has to prove under this kind of unique bill of review scenario is that the plaintiff's failure to file a motion for new trial is the result of an official mistake. In this case, that official mistake is the court's clerk's failure to send notice of the default judgment to Mr. Patel. There is no notice on the docket. The docket says that notice was sent to select parties in the underlying lawsuit. And if that's clicked on, it actually only shows that notice was ever sent to Couture Hotel Corporation through their counsel, Mr. Strother. After that element being met, what the plaintiff would have to prove is that the plaintiff's failure to file an answer was not intentional or the result of conscious indifference. Again, that the plaintiff has a meritorious defense to the allegations made in the underlying lawsuit, so that is still similar to the Hagendorf standard we looked at earlier. And finally, that no undue prejudice, delay, or injury will result to the opposing party. So I think there are some key dates here for the court to consider. The first being August of 2018. On August 2018, Mr. Patel moves from 3840 Innisbrook Drive in Irving, Texas, to 7216 Bremer Terrace in Colleyville. He eventually does sell the Innisbrook address, but does not rent it out to anyone. It more or less remains empty. March 20th, 2019, that is when the transaction and the underlying lawsuit takes place.
Let me ask a question. At the time that service was completed, did he still own Innisbrook?
No, the civil service was never, as far as our contention, Your Honor, is that service was never
Okay.
completed.
So when the subservice was signed,
When the substituted service was signed, he had sold the property.
so he no longer owned Innisbrook.
Correct.
Okay.
March 20th is the underlying transaction. For the sake of brevity, Your Honor, I'm not going to get into the details about the merits. If we have to open that up, I can, or would you like me to just do the full opening?
No, let's just deal with service.
Got it. On April 8th, 2019, Couture files suit in the underlying lawsuit, cause number DC 19-05050, and Mr. Patel is not listed as a party. On May 10th, 2019, Couture adds Mr. Patel as a party to the underlying lawsuit. And in that pleading, Couture represents that Mr. Patel's address is the 3840 Innisbrook Drive address. In November of 2019, there are various unsuccessful attempts to serve Mr. Patel. I'm going to skip this for now because it's more related to the underlying merits. On December 12th, 2019, Couture files its motion for substituted service regarding Mr. Patel. And in that motion, again, represents that Mr. Patel resides at the Irving address on Innisbrook. On December 27th, 2019, Mr. Patel sells 3840 Innisbrook Drive. And on January 7th, the court grants the motion for substituted service. Again, the Couture attempts to effectuate service thereafter. However, Couture does not strictly comply with the court's motion for substituted service, meaning there was no service. In fact, February 4th, 2020, it's shown on the UPS website that the certified mail return receipt requested that was sent to the Innisbrook Drive address is returned as unclaimed and being returned to the sender. Over 2 years later, Couture moves for a default judgment on June 15th, and again continues to say that Mr. Patel's last known address is the Innisbrook address in Irving. At this point, he hasn't lived there for almost 4 years, and he hasn't owned it for over 2.5. On June 17th, 2022, the court enters the default judgment against Mr. Patel. But again, as I alluded to earlier, there is no entry that the notice of default judgment was sent to Mr. Patel. Fast forward all the way to August 2023, Couture files an application for writ of garnishment on that default judgment. They do correctly cite Mr. Patel's current address here for the first time with default judgment in hand at the Colleyville address. And on August 14th, 2023, Mr. Patel, for the first time, learns of the default judgment and learns of the underlying lawsuit when he receives a phone call from his bank about the garnishment. On August 17th, Couture serves Mr. Patel with a deposition notice related to, I'm assuming, post-judgment discovery, again, correctly cited at the Colleyville address. And finally, on August 19th, 2023, Mr. Patel meets with and retains counsel. And that just is kind of a quick timeline for you, Judge, on the dates that are more relevant to the service issue.
Okay, great. Let me hear a response.
Thank you, Your Honor. This case is really not as much about facts as it is about law. As I stated during the housekeeping phase, Couture Hotel generally agrees with the concept that the burden is on plaintiff Mr. Patel today to prove that service was inappropriate or improper, was ineffective. Couture Hotel asserts that Mr. Patel was adequately served twice. Once on November 14th, 2019, when he did own the Innisbrook property, and then in early January of 2020, pursuant to this court's Rule 106 substitute service order.
So explain that first one then, the November. He was served in November. What do you mean?
Sure, Your Honor. So there is a return of service by a process server named Cherry Davis. As this court is probably aware, the
Why
comments
would you, if you already served him, why would you do a subservice?
belts and suspenders, Your Honor. Let me give you a few more details about how the service happened on the 14th and why that caused me concern as the attorney for Couture Hotel. So on November 13th, 2019, the process server went out to Mr. Patel's property in Irving. No one was there. She left a card. The very next day, on November 14th, Mr. Patel called Miss Davis and said, "I'll meet you." And so she met him, she gave him the document, and he looked at it. The citation says, "You're sued." By the way, both opposing counsel are shaking their heads right now, and if they want to jump in and go ahead.
I'll object, Judge. I didn't want to interrupt an opening statement. It's a misstatement, and we'll show the court why. He was never handed the document. That's fine. I just wanted to make sure the court's aware of that, at least from our position.
Okay, Mr. Strother, don't do that again.
Okay. Mr. Patel, according to Miss Davis, said that upon looking at it, he's on a number of LLCs. The one that the process server has doesn't have anything to do with them, and he refused to take the papers. We contend that under the law, the physical refusal to keep the papers acts as service. However, Your Honor, I wasn't very comfortable trying to get a motion for default judgment filed with just those facts alone. So we sent the process server back.
Did the process server actually, like, she handed him the paperwork and then he handed it back, or what? He obviously looked at it according to her, right?
Right, and I think that's why Mr. Nowak was shaking his head, because what Miss Davis wrote in her declaration, and let me remind everyone here that her declaration is irrefutable as a matter of law by uncorroborated testimony from Mr. Patel. Mr. Patel in his deposition hasn't contested this. He just denies having a memory of the details, but what she has put here in the return of service is afforded at this point uncontestable matter of law status. So she writes that upon arrival, Mr. Patel stated he is on a number of LLCs because of his motel business, but the one I have has nothing to do with him. He refused very nicely to take the papers, stating he was not the registered agent and did not know any person or business identified. Now, Your Honor, the case law says that this court is supposed to use the return of service and read all reasonable details into it that support those words. Our contention is, of course, he took the papers to be able to say, "No, this isn't me right here." Now, again, Mr. Maserati is
just keep going that they respond.
Well, I mean, I'm addressing his concern. During my deposition, he's like, "Well, couldn't he like look at it from 3 feet, 4 feet, 6 feet and say, well, that's not me?" Your Honor, our contention is the citation says, "Mr. Patel, you have been sued." So anyway, Your Honor, you can tell why I went ahead with the belt and suspenders approach and decided to go ahead and ask this court to grant a Rule 106 motion for substitute
Did you
service.
ever file the return of service on that November
Yes.
service?
Yes, Your Honor. So that process server went out a total of 7 times. She, a couple of days later, after trying to go back to his place, called him, and he answered the phone and said, "I'm out of town all weekend. I'll call you Monday."
No. Go back. So you're claiming service on November. Did you ever file the return of service prior to the default judgment?
Yes.
Of that return of service?
Yes, Your Honor.
When?
I don't have the file date, Your Honor, but it's in the court's record. I can get it for you in a moment. But it would have been, the process server would have did file it within a couple of weeks after receiving the final, after completing her final attempt.
Hey, Judge, I don't mean to interrupt. I just want to make sure I'm understanding, because I want to be real clear about this, because I'm going to be obviously taking the witness on cross. But is the court asking under Rule 107? I think that's what the court's asking. Did they on November 14th, the 2019 service, did the service process actually say that she served Ms.
No, that's not what I'm asking.
Okay.
I'm asking that when she completed this return of service, did she file it with the clerk?
Yes, Your Honor.
Okay.
And that would be.
Sorry to interrupt. I wanted to make sure I was clear. Okay.
Okay. I mean, that may be, I'm not saying that that's not a good question that you have, Mr. Noack, but that's not the question I had. So
Okay, I apologize.
that's all right.
Your Honor, I'll get you the date in a moment, but yes, that one was filed, and then we sent a different process server out before filing the motion for a substitute service. He made 5 attempts and filed his return of service, but there's not a whole lot interesting about his return of service other than the cards he was leaving kept disappearing. Then we filed the motion for default judge. I mean, sir, I'm sorry, Your Honor, the motion for substitute service in December. At that point in time, it's uncontested that Mr. Patel did own Innisbrook. The court granted the motion in early January 2020, and Mr. Patel contends that by that point, he had actually transferred ownership of Innisbrook. And so the issue before you, Your Honor, is when this court in January granted our motion for substitute service, and then the process server went out again in January and complied with the court's order, tacking the citation, the order for substitute service, and the petition to the door, sending it via certified mail to Innisbrook, and sending it by U.S. mail to Innisbrook. Does that satisfy Rule 106? And so we're contending that both of those circumstances meet the requirements. Again, this is mostly an issue of law, Your Honor, about whether Mr. Patel's behavior in November and December in his practiced efforts to cloak his home address, because, Your Honor, he was using this as his address still into 2021, filing deeds with the real property records listing it as his address. So we contend that to the extent that there is a bad bed that someone has to lie in, it's Mr. Patel's bed that he, through intentional effort, built for himself.
All right, let me show you something on the clerk's record. I've gone back and looked at, do you see that?
Yes, Your Honor.
So, I mean, none of this, I just want to figure out this issue, this November service. If you look at the clerk's records, it claims the service was completed on 1/14/2020. And this is very unusual. There isn't any, usually there would be something here filed to indicate when that occurred. If you go back to the summary here, I'm looking and I need to know when supposedly this November service was filed, because I don't see it. I see where Mr. Krothapalli, it's Krothapalli, was served. His return of service was filed. I'm trying to find where the return of service that you're claiming was completed was filed.
Your Honor, if I may address your concern, and this goes to Mr. Noack's question previously, Couture Hotel does not contend that the return of service indicated to the court that service was effective in that November 2019 effort. I was just answering the court's question that the declaration was filed with the court, not that it was noted by the process server that service was effective.
Okay. I'm not getting this across, and I'm really trying to, because to me, this is a really threshold issue. If the return of service, if the process server never filed, and if you never filed a return of service indicating that this service was completed in November, then that's a complete red herring. We don't need to go into any of that, because in order to support a default judgment, you have to file the return of service, right? At least 10 days before the default. Maybe I'm missing it. I don't see where this return of service was ever.
I can cut past. I'm sorry, Your Honor. Given what you just said, our motion for default judgment was not based upon service in November. It was based solely upon the substitute service in early January 2020.
Okay. I appreciate you saying that. But was the return of service ever filed for the November service? I
Your Honor,
don't see it on the system. Was it ever filed?
that's a great question. I've been telling you, Your Honor, that it was.
And it's, I don't see it. Maybe it's somewhere that sometimes clerks that do it correctly. Sometimes, maybe I'm just missing it, but I don't see that based on my cursory review of the record, maybe it's this. Is that it? Return of service.
It would have been called a declaration of due diligence when it was filed rather than a return of service.
Well,
But
the
I'm looking
November service would have been.
correct, Your Honor.
Why is the November service, if it wasn't filed and you why was it okay? In order for it to be a return of service, is my understanding, this is how I've been doing this for the last 18 years, but not addressed this issue before. With a process server complete service, they have to file the return of service at least 10 days before the default judgment is indicated. You seem to be relying on this November filing or service attempt or whatever it is to support that your the default judgment in this case. But if that return was never filed, you kind of been saying.
Your Honor, I think we lost.
I think we lost the judge. Yeah.
Oh, boy.
Sorry about that. Just one moment. We'll be right back.
Okay, everyone, can you hear me?
Yes, Your Honor.
My computer went out. I'm not sure why or what happened. It's just died. I don't quite understand it. But okay, so I guess I'm not explaining this very well, and I'm not, or maybe I'm Mr. Schroeder, you're kind of saying two different things. The November service that you guys have been talking about, in order for that service to be completed, my understanding of the law is that not only does the process server have to go out and do it, they have to fill out a return of service that has to be filed with the clerk before the default judgment is entered. If you want to use that November service as a basis for supporting the entry of the default judgment. Was that ever filed with the clerks or not?
No, Your Honor, it was never filed as a return of service. So I'm attempting.
Then why is it relevant in this case?
Your Honor, we think that I don't want to waste too much time, Your Honor, on this issue. I understand the court's reading of the law regarding the return of service needing to be on file to support a motion for default judgment. That wasn't our argument at the time we filed the motion for default judgment, nor was it before the court as an issue when the court granted the default judgment. Default judgment was solely about substituted service. So
then why do we need, if that's the case, then why do we need to go into all of this testimony? I guess there's been quite a bit of testimony about this, about what happened on the November service if the return was never filed.
Judge, if I may briefly, I'm going to have to get into it for one real purpose. As the court is aware, under Rule 106, they are to try or at least attempt effective service under Rule 106A and B before they're allowed to get into substitute service. And the other relevance, at least from our vantage point, is going to be to explain to the court when someone comes to the court to do substituted service, they have to present, say, we tried, this is what happened, and we're going to be able, I think, to be able to show the court that there were some inaccuracies in the substitute service based off what they're saying is the service. So that's just from our vantage point. Well, I'm going to get into it a little bit when I do my cross. I wanted the court to be aware of that.
I don't know that that's necessary, but Okay, my computer's back on, so hopefully we'll be able to get going. So, all right, call your first witness.
Your Honor, Mr. Matthew Nowak, on behalf of Mr. Patel, we're going to call Mr. Strother. I know this is a little unusual. Mr. Strother was designated as their corporate representative for Couture Hotel dealing with service issues and factual allegations dealing with the service issue regarding the default judgment, I believe the underlying case, the bill of review, and so forth. And so I just wanted to make sure, I've only done this twice before where the lawyer is actually the witness. So I'll be real careful when I ask the questions to let him to object and then go forward.
Did you tell Mr. Strother you were going to do this?
Well, he was aware he was being called. He's on our witness list, and he's also already been deposed on these issues, Judge.
Okay.
Yeah, Your
that's
Honor,
fine.
yeah,
It's not like it's some surprise. He was deposed by Mr. Mazahari and all that. So that's why we're calling him. I just wanted to be the court to be aware that, like I said, it's fairly unusual. So I'm going to do my best when I ask my question to allow Mr. Strother as the attorney to object, I assume, and then proceed with him as a witness.
Okay, sounds good. Mr. Strother, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
yes,
All right, let's proceed.
And Your Honor, if I may, can you allow me to have the share screen because I am going to be putting some exhibits in front of Mr. Strother and the court?
Give me a second if I'm not sure I can do that. Let's see. I guess go ahead and start your testimony and I'll see if I can enable that. I'm not sure how to do that on my phone. So give me a second. Go ahead and start your testimony.
Okay, Your Honor. Mr. Strother, to begin, you're the attorney who represented Couture Hotel Corporation in the underlying lawsuit, Couture Hotel Corporation versus Sayababa Hotels LLC before this court in cause number DC 1905050, correct?
yes,
You were also the attorney who represented Couture Hotel Corporation in this bill of review before this court and this cause number DC 2313242, correct?
yes,
You were also designated by Couture Hotel Corporation as its corporate representative on certain topics listed in a notice that we marked as Plaintiff's Exhibit 33. And Judge, if I had the ability.
Give me a second. Okay, you can go ahead and share screen now.
Thank you, Your Honor. And I'm not offering this into evidence. I just want to be able to show the witness, Judge, just so.
Right now. Okay, there we go.
Yes. Okay. I'm handing you, Mr. Strother, which has been marked as the notice of intent to take the oral deposition of the Couture Hotel Corporation's corporate representative. And in fact, you were deposed, were you not, on January 3rd, 2024?
I wouldn't swear to the date, but I believe if that's the original notice, that date makes sense. I was deposed.
Okay. And I'll represent, you're looking at your deposition transcript and it says January 3rd, 2024. So I'm not trying to trick you.
No, of course.
Okay. I want to go to the topics because we designated a lot of topics, but there was only certain topics that you agreed to for your deposition. I just want to make sure the ones that you were presenting testimony and that I'm going to be asking you questions about here today. The first one was topic 2, the factual basis to support any allegations or causes of action and any pleadings or motions in this bill of review proceeding. That's one of the topics. And I'll represent to you. I'm going to show you your objection. So I'm not trying to trick you here. I just want to go through the topics first, and then I'll show you your objection. So topic 2 was one of the topics you were presented for, correct?
I would really defer to the objections and the designations. My recollection is that Couture Hotel designated 2 witnesses
Okay.
in response to a long list of topics. And so,
well, I'll represent to you. I read your deposition, and I'm going to go through this as quickly as we can. Topic 2 was one of the ones that you presented yourself on behalf of Couture Hotel Corporation. Do you dispute that fact?
No, I recall at the beginning of the deposition, Mr. Mazarahi went through all of the different topics I was designated on, and we went through all of those. So what I said in my deposition, I stand by now. I just don't recall right now.
That's fine. So topic 2 would be one that you were presented, and I'll show your objections in a second. Then also topic number 6, the factual basis related to any surface efforts on Mr. Patel in the underlying suit. You were presented on that. Do you dispute that fact?
What I recall is that we did make various objections to the various topics, and I don't recall those right now. So we presented me subject to those objections on a number of topics. Number 6, probably. But again, I defer to the document. You've got that one. I defer to.
Okay, we're just gonna shoot to this, so make it quicker and more efficient. I'm gonna go to what I've marked as plaintiff's exhibit 34, Mr. Strother. These are the objections to the notice of the Couture Hotel Corporation's deposition as a corporate witness, and the topics that you were presented on. I'll represent to you, you were presented on topic number 2. You did have some objections, and then the answer that you were going to be providing as a corporate representative, it was defendant will designate a witness or witnesses to testify regarding the factual basis supporting defendant's allegations. That's what you wrote, and I'll represent to sir, that's what you testified in your deposition. Do you recall that?
Don't, but I stand by what I said in my deposition.
Okay, so if I have to, I'll go through the deposition. If we need to do that, I guess we can here in a second. I want to make sure the record is clear on what you testified to. In fact, I guess we'll just go to your deposition because this is too important. I'm going to hand you what's marked as your deposition, sir. Dated January 3rd, 2024, in which you were the corporate representative presented on behalf of Couture Hotel Corporation. Do you recall giving your deposition in this case, sir?
I do.
You also recall that you had a chance to review this deposition and make any revisions, and I understand that the court reporter filed a errata sheet in which no changes were made. Did you make any changes to this deposition?
I don't believe so, no.
And you understand you were under oath and you were providing testimony on behalf of Couture Hotel Corporation, correct, sir?
Both, yes.
This is when the deposition notice was presented to you. It says one of the topics you have been designated on is topic 2. Is that correct? What was your answer?
Yes.
Okay. Moving along. Going to page 22 of your deposition, it says you will also been designated to provide testimony on topic 6 here in exhibit 1. Is that correct? What was your answer?
Yes.
Moving forward, you also have been designated to provide the testimony on topic 7 in exhibit 1. Is that correct? What was your answer?
Yes.
Question, you've also been designated to testify on topic 8 of exhibit 1. Is that correct? What was your answer?
Yes.
Next question, you've also been designated to provide testimony on topic 9 in exhibit 1. Is that correct? What was your answer?
Yes.
And then lastly, question, you have also been designated to provide testimony on topic 11 in exhibit 1. Is that correct? What was your answer?
Yes.
All right. Let's go now to exhibit 34. Excuse me. Exhibit 33, which is the notice of intent to take your oral deposition of the corporate representative, which was exhibit 1 to your deposition. I want to talk about the topics that you were providing testimony on behalf of Couture Hotel Corporation. Topic 2, you were going to provide testimony on the factual basis to support any allegations or causes of action and any pleadings or motions in this bill of review proceeding. That's what you were presented for, correct?
Subject to the objections, yes.
Okay. Same with topic 6, the factual basis related to any service efforts on Mr. Patel in the underlying suit. You were going to provide testimony on behalf of Couture Hotel Corporation, correct?
Subject to any objections that we filed before that deposition, yes. And that'll be my answer to all the ones from that transcript, right?
Well, and we'll get to that. I'm trying to do this as quickly as possible. Topic 7, the factual basis related to any service efforts on Mr. Patel regarding the motion for default judgment in the underlying lawsuit. You are providing testimony on behalf of Couture Hotel Corporations on that issue, correct?
Mr. Nowak, I'm not trying to be difficult. I'm not writing this down. Whatever you just went through that I said yes to, the answer is yes. Of course,
Okay.
subject to objections, which were, we went through during the deposition as
I-
well. I just don't know that.
I understand, sir, but I want to make sure, and I want the court to be clear about this. You're being presented as a corporate representative for your client, Couture Hotel Corporation, on these very important issues in this bill of review on the issues involving service. And that's where I'm kind of getting to. And I want to make sure we're all clear on the record. That's why you were providing that testimony and you were the guy. And so
I am the guy.
Okay.
Yes.
Okay.
That is undebated. I am the sole witness on behalf of Couture Hotel, and I actually have personal knowledge of service. Yes.
And that's where I was going. So just so we can cut to the chase, if you look at and read on the screen, topic 6, topic 7, and topic 8, which is dealing with service efforts on Mr. Patel in the underlying lawsuit, the default judgment, and also related to the default judgment, again on 8 and further on 9, following the default judgment, you would agree you were designated on all those issues, and I'll show you that there was no objections presented by Couture Hotel on topic 6, 7, or 8, were there? Looking at your responses.
Well, no, I think there's an objection that at the very beginning of this exhibit that apply the general objection, which applies to all of them.
Sure.
So, but yeah, no, I get your point. I'm the guy to talk about service, and I'm the guy to talk about the efforts to get the default judgment. Like, there's no debate.
Mr. Nowak, let's move on.
Okay. I just want to make sure we're clear on that.
We're clear. Let's move on.
And I think you stated just a minute ago, I want to make sure, you said you had personal knowledge of these issues and you were the guy, correct?
Yes.
Okay. Now, just so the court's clear, this Miss Sherry Davis, who was one of the process servers in this case, did you ever speak to her or have conversations with her to gain this personal knowledge?
Oh, no. I mean, I may have spoken with Miss Davis, but my recollection and what I'm testifying about is not based upon any conversation because I don't remember if I did or didn't. I might have, I just don't remember.
So fair statement, then your personal knowledge related to the service issues in this is really relying upon Mrs. Davis, is what I'll call her declaration that we'll be able to look at in a moment, but not based on any actual verbal conversations with her. Is that correct?
That's accurate.
And do you know, sir, we found out, Mr. Strother, that Miss Davis unfortunately passed away.
I am aware of that now.
Okay, because we wanted to call her as a witness. I just wanted to make sure if you were aware of that fact. Okay.
Object to the sidebar.
Stay.
Your Honor, we'd like to offer into evidence plaintiff's motion for substituted service on Jay Patel. This is plaintiff's exhibit number 4 into evidence. It's a plea.
You don't want me to just take judicial notice if that wasn't that filed with the court?
Well, I could do that too, but it has some declarations attached to it as well, but it was filed by opposing counsel. So
No objection.
Okay, that's exhibit what?
exhibit 4, Your Honor.
Exhibit 4 is admitted.
Thank you. Mr. Strother, you would agree Couture Hotel Corporation filed plaintiff's motion for substituted service on Jay Patel on December 12, 2019. Is that correct?
I see that there. Yes.
And attached to this substituted service motion, we had 2 exhibits. Exhibit 1, which was the declaration of Cherry Davis of due diligence, and exhibit 2, which was the declaration of Guy Connolly of due diligence. Is that correct?
Yes.
And in all fairness, sir, you were the attorney that actually filed this document, were you not?
Yes.
And is that your signature there, sir?
Yes.
On page, I believe, 2 of the document. I would like to first go to paragraph 3 on plaintiff's motion for substituted service on Jay Patel. The statement that is written there. It says defendant is an individual defendant in this case, and his status as registered agent is irrelevant. That is what was written, and that's what you presented to this court. Is that correct?
Yes.
Now, with regard to that, do you or do you not know, Mr. Strother, that my client's legal name is Jagdish Kumar Patel, Jagdishkumar, and the last name Patel. Did you know that?
I do not know that.
Okay. So at the time you filed this document, you were not aware that his legal name was Jagdish Kumar Patel. Is that what you're telling this court?
Yes. I don't know. I just don't know that as I sit here, in fact.
So you don't recall, or are you saying you knew that? I just want to make sure we're clear on the record.
No, I don't know that Jagdish Kumar is his legal name. I don't know.
Okay. I'd like now to go to Exhibit 1 of this motion for substituted service. This was the declaration of Cherry Davis of due diligence in which Ms. Davis attempted service on Mr. Patel in November of 2019, is it not?
Yes, it is.
Now, as a corporate representative of Couture Hotel Corporation, you swore under oath, and it was Couture Hotels Corporation's position that Mr. Patel was served on November 14th, 2019. That's what you told us. Is that correct?
I said that is Couture Hotel's contention. Yes.
Okay. You also told us at the time of your deposition that Couture Hotel's position is that it also had never stated or filed anything with the court that service was effective on November 14th, 2019. Is that correct?
I don't remember what I said, but it is correct.
Well, we can go to your deposition real quickly here.
I'm not denying that I said it.
Okay.
I'm telling you I know that to be correct. I just don't recall what the testimony was.
Okay.
Denying it.
Now, with regard to this declaration that was trying to be served in November 2019, this was plaintiff's first amended original petition. Is that correct? If you look at the
Yes.
screen. And Judge, we'd like you to take judicial notice of plaintiff's exhibit number 2, which is plaintiff's first amended original petition.
Okay.
No objection.
And actually, I'll just offer it into evidence, exhibit 2.
No objection.
Exhibit 2 is admitted.
And plaintiff's first amended original petition, that was filed on May 10th, 2019, was it not, sir?
Yes, that's what it says.
And just to be real clear, in the caption, is Mr. Patel's name listed at all in the first amended original petition?
No, pursuant to the rules, the caption was frozen in time.
Okay. And fair statement, you do not see Mr. Patel's name until we get to page 2 of the original petition, correct?
Of the original petition or the
No,
amended?
excuse me, the amended petition, exhibit 2 that we're looking at.
If I understand you correctly, are you asking about just the petition or what was actually shown to Mr. Patel? Because the first page would have been the citation.
I understand that. I'm not even talking about the service. We're just talking about this document, sir. So, Mr. Strother, if you look at plaintiff's first amended original petition, on the first page, is Mr. Patel's name listed at all?
It is, yes, it is. First paragraph.
Okay, and what name is listed?
J. Patel.
Okay. And then if you go to the second page again, we see the name listed there again, correct?
I do.
You would also agree within this petition, the legal name of Jagdish Kumar Patel is not listed. Is that correct?
Jagdish Kumar is not used in that petition, to my recollection.
Okay. Like go back to plaintiff's exhibit 4, which is the motion for substituted service exhibit 1, which is the declaration of Cherry Davis of due diligence. I'd like to focus in on this one entry here, which is very important. November 14th, 2019 at 3:10 p.m. And I'm just going to read this aloud and we're going to break it down a little bit, Mr. Strother. It says at 3840 Innisbrook Drive in, I guess for North, Irving, Dallas County, Texas 75038. I received a call from defendant number 580/309-0639, comma, telling me to bring him the documents. Upon arrival, Mr. Patel stated that he is on a number of LLCs because of his motel business, but the one I have has nothing to do with him. He refused very nicely to take the papers, stating that he was not the registered agent and did not know any person or business identified. Then in parentheses, Indian male, 5'8", 175 pounds, 50s. He stated that your office could call him if they wished. Did I read that correctly?
Yes.
Okay. And again, this is the date that you mentioned in your opening on behalf of Couture Hotel, that it was Couture Hotel Corporation's position, as you testified in your deposition, where this was service was the first time on Mr. Patel. Is that correct?
Yes, but I think it's important to note that Judge Hoffman has backed me away from that position, but I did testify to that.
No, and I understand, but I want to get into it a little bit because I think it's going to be important when we get into the substituted service.
Understood. Fair enough.
Good. If you look at that entry, sir, you'd agree with me. Nothing within November 14, 2019 at 3:10 p.m. from Miss Davis indicates that she actually served Mr. Patel. Fair?
No, I don't agree.
Is the words anywhere within this entry that she actually delivered or handed the document to Mr. Patel?
As I stated in the deposition, I think it's reasonable to understand that she did hand it to him so he could look at the document.
Objection non-responsive. That wasn't my question, sir. With anywhere within this paragraph, does it state from Mrs. Davis in her declaration that she actually handed the documents to Mr. Patel?
Not in those words.
I really don't know why this is relevant at this point, because he's already admitted that he's not attempting to assert that the November service was the basis of the, I mean, you can go on for.
I'm just going to go on a little bit, Judge, because it's going to get into, I don't want to kind of tell the court where I'm going because this is the witness I'm dealing with, but it's going to get into the representations made to this court on the substituted service. So that's where I'm going.
That's fine.
Okay. With regard to the fact, let's go a little bit down to November 23rd, 2019 entry at 5 p.m. Miss Davis wrote, did she not, at 3840 Innisbrook Drive, North Irving, Dallas County, Texas, 7508. No response at door, no vehicles, no visible lights. I placed a call and left a message for defendant. Then in parentheses, note, I did not know to drop serve paper on first attempt when defendant refused. And now I'm fairly certain he's going to continue to avoid me. Into parentheses. I don't have a problem with continuing to go over there, but we'll probably get same result. That's what was written, was it not?
Yes.
So within that entry, Miss Davis said, I did not know to drop serve paper on first attempt, correct?
Yes, that's what she wrote.
And I want to get into this document a little bit more because 3840 Innisbrook Drive is an important address because that's the address in the substituted service, which in this motion that you were you utilized, excuse me, to serve Mr. Patel in the substituted service, is it not?
That is the address that we requested substitute service at. Yes.
Okay. And why I want to go through this with you is, and all these entries on November 13, 2019 at 5 p.m., there were no vehicles present, according to Miss Davis, correct?
I don't agree with that. On November 14th, she doesn't indicate. And if Mr. Patel was there, he certainly had a vehicle there.
Well, I'm objecting non-responsive because we're going to get into that in just a second, sir. My question was really just on November 13th. I didn't go to November 4th. Let me ask you, November 13th, were there any vehicles present?
No.
On November 16th, 2019, were there any vehicles present?
No.
On November 9th, 16th, that's the same entry, I apologize. November 18th, 2019 at 6:05 p.m., were any vehicles or lights, any vehicles present?
No,
On November 23rd, 2019 at 8:30 a.m., were there any vehicles present?
well, she notes there's no visible vehicles, which suggests that maybe there were vehicles inside of a garage that she couldn't see. So she wrote no visible vehicles.
Okay. And on November 23rd, 2019 at 5 p.m. at that same address, she wrote no vehicles again, correct?
True.
So on 1, 2, 3, 4, 5 out of the 6 dates in which she attempted service at 3840 Innisbrook Drive, North Irving, Dallas, Texas, there were no vehicles present noted, correct?
No, one of those, she said no visible vehicles. So I don't mean to split hairs, but if you're making a big deal out of there being vehicles or not, I need to make a big deal out of the fact, well, maybe there was on the 23rd.
Okay, let's go. The 23rd, she says no visible vehicles, and I am unable to see if a vehicle is in the garage. So she didn't see a vehicle in the garage either, did she?
Right. True.
And the reason I'm going
no, she said she couldn't see. So I think that's a different point. I don't understand the importance, but I'm answering your questions.
Sure. Where I'm getting at is on those 5 out of the 6 entries, it appears on 4 of them, there's no vehicles present. And then on the one that you're trying to make an issue out of, she was unable to see if a vehicle was in the garage. Is that correct?
I think so.
Okay. And then on many of these occasions, it looks like there were no lights. I read here, it says, I believe, no vehicles or lights were observed on November 18th, correct?
That's true. Generally speaking, she noted several times that there were no lights. Not every time, but
okay.
Some.
Okay. And then let's go to the November 14th, 2019 entry again. Now, obviously, she met with Mr. Patel, correct?
Obviously.
But within this entry on November 14, 2019, you agree with me, it does not say, or there's insufficient evidence to determine if she met Mr. Patel at 3840 Innisbrook Drive or where she met him, correct?
I've changed my mind on that. No, I think that she's stating that he met her at 3840 Innisbrook Drive.
Okay, well, Heyman, you just said you changed your mind. Do you remember giving your sworn deposition testimony in this case as the corporate representative for Couture Hotel Corporation?
I do, and I remember saying that it was not clear to me where they met, but maybe they didn't even meet at Innisbrook. Like I said, I've changed my mind.
Okay, well, you had the chance, did you not, Mr. Strother, to change that sworn deposition testimony in an errata sheet? You did not do that, did you?
I don't think I had the opportunity to change my answers. I had the opportunity to correct typos and misstatements.
Or clarify answers.
Hold on, I wasn't finished, but I was reading my deposition this morning to get ready for trial, and I went across that part, and I realized that I had just jumped to the wrong conclusion. So, no, you're right. Upon reading this the first time during my deposition, I jumped to a different conclusion. Reading it again, I realized I was wrong.
Okay, let's go to that testimony.
I think you should just look at the words themselves rather than what my perception of the words was.
Sir, objection non-responsive. Sir, you were presented as the corporate rep for Couture Hotel Corporation. You're also the attorney. You know how this works. Your testimony is relevant to this proceeding in the bill of review. And so I want to go to the testimony in which we talked about, or Mr. Mazahari talked to you about what you testified to with regard to the location at this particular address.
It's just that you were asking me what my interpretation was of Miss Davis's declaration of due diligence. I'm saying that was my interpretation. I'm not saying, that I didn't say those things. I'm saying I have a different interpretation now. And so I would encourage you just to look at it. But I'm happy to go through my old testimony. I just don't agree with it anymore.
I'm going to hand you what's been marked as your deposition transcript, sir. And we're going to go to page 45 of your deposition. Are you there? Can you see it on the screen?
I can see, yes, lines 1 through 20.
Thank you. All right. And the question was asked, by Mr. Mazahari on line 9 beginning, and I'll give you a second to just look at their declarations here. And on line 11, they only tried to serve Mr. Patel at the 3840 Innisbrook Drive address, correct? And your answer was on line 13. What was it?
I'm not sure where Miss Davis ended up meeting Mr. Patel.
And then Mr. Mazahari says, okay. And then you go on to answer on line 16 through 17, what?
Back then I said, her declaration is unclear whether she met him at 3840 Innisbrook or somewhere else.
Then the question by Mr. Mazahari on line 18, is there any evidence that they tried to serve Mr. Patel anywhere else other than 3840? Any conclusive evidence? What was your answer?
I said yes, but I correct that later on in the deposition.
Okay. Then we go on the question on line 24. When you say there's conclusive evidence they tried to serve him other, are you still referring to that conversation? Your answer on line 2, beginning on page 46, was what?
Yeah, I didn't hear you say conclusive. No, there's only evidence that Miss Davis may have tried to serve him, did serve him at a different location on November 14th, 2019. It's unclear to me from her declaration where she ultimately did that.
All right. So my point being, at the time that you gave your sworn deposition as the corporate rep for Couture Hotel, you gave the testimony on the service of process issue, and you indicated on that November 14th, 2009 entry we've been looking at, that it was unclear to you from what you looked at and in the personal knowledge and all the documents you looked at that time, you said it was unclear that they had met at that address. Is that correct?
No, based solely upon this declaration, I said it was unclear to me where she ultimately met him. And that's what I'm saying now. It's clear to me, but it wasn't clear to me in January.
So just a month ago, it was not clear. Let me be real clear on the record, because I think credibility and representations of the court have become an issue here. So in January of 2024, Couture Hotel Corporation's position was it was unclear if they met at this address on November 14th, 2019. And now it is clear to Couture Hotel Corporations that they did meet at this address. Is that what you're telling the court?
Object to the sidebar about credibility being important.
Is that what you're telling the court?
I am telling the court that if the court were to look at the November 14th entry here, it would be clear to all of us that Mr. Patel met her at 3840 Innisbrook Drive. Given the way that she's listed this here, she would have listed an alternate address, being that she's the process server. And so it's just a detail that I didn't think about when I was giving my deposition in January. Reading it now, getting ready for trial, it should be clear to you.
It's not clear to me. And Mr. Strother, I'm going to object to some non-responsive portions. Let's be real clear. On this November 14th, 2019 entry that Miss Davis made, the document obviously will speak for itself. And we all know that Miss Davis is passed away, correct?
Which part of that?
Let me ask you twice. The document will speak for itself. You'd agree with that, correct? The judge can read it.
I agree. The judge can read it.
Okay. And as far as any inferences you're making or things you're discussing or saying, you have not spoke to Miss Davis, and you told us you did not rely on any conversations with her for Couture Hotel Corporation's position, correct? So basically, anything you're talking about this entry is how you're reading it now, a month later. Is that correct?
I object to the multifarious nature of the question. I don't know what your question actually is.
Well, I just want to be real clear. In January of 2024, when you gave your sworn deposition, your position was, and Couture Hotel Corporation's position was, that they may not necessarily have met at the 3840 Innisbrook Drive address. Now that has changed a month later. That's what you're telling us, correct?
Don't know how I could be clearer about that. Yes.
Okay. And that's based off what you're telling me is because this entry, which says at 3840 Innisbrook Drive, I received a call from defendant. That's what you're basing it off, correct?
You read it incorrectly, I think. You're reading it as one sentence, and that was my initial mistake as well. She has listed the date and where she attempted service, and then she has an entry. There's a failure to have a dash or a colon or a period. But when you read everything together, you realize that's where she's making the service attempt. So you read it correctly. Okay,
well, let's do this. I'm just so we're real going to be on grammatics here. The first sentence says on November 14, 2019 at 3:10 p.m. at 3840 Innisbrook Drive, North or in Irving, Dallas County, Texas 75038. I received a call from defendant, comma, 580/309-0639, comma, telling me to bring him the documents, period. That's the first sentence, is it not?
I think you got most of the punctuation in there. Yes.
Okay.
No, I don't agree that that's the first sentence. That's my point. No, you're reading it wrong.
Okay,
I just
I'll just object to non-responsive. The document will speak for itself. I'm going to move on. But the fact is, you've changed the testimony. You'd agree with that?
no, I haven't changed the testimony. That was what I believed it to be back then. I'm telling you that my interpretation has evolved
Okay.
as I've thought more about this document.
All right. Mr. Strother, with regard to these issues of service, you'd agree there was at least 1, 2, 3, 4, 5, 6 attempts at this address, correct?
6 attempts. Yes.
Okay. And you'd also agree with me, we already talked about the entries that talk about no vehicles present and so forth. Is there anything within any of these entries by Miss Davis that indicates that 3840 Innisbrook Drive was the home of Mr. Patel?
Yes.
She actually uses the word that this is the home of Mr. Patel.
No, that wasn't your question.
Yes, I said, was there any words in here that identify that this is the home of Mr. Patel?
Yes. Yes. On November 13th, she said Central Appraisal shows Jagdish Patel as owner of the provided address. Then when she actually met him out there, he didn't indicate that it wasn't his home. And finally, she placed a call to him and he said he was out of town for the weekend and would call him, that's not my house. So yeah, I think all over this, it's clear that she believed that that was his home.
Ms. Strother, I'll object to non-responsive. We're gonna have to go through this I understand you're the attorney, so this is a little different, but let me be real clear on this. Point to anywhere within this document for the court where Miss Davis indicates that it is his home. She says owner of provided address. Where does it say it's his home or residence?
Well, you're splitting hairs. He doesn't.
No, I'm not. This is an important issue.
She never uses the word home or residence. I'll grant you that.
All right. Now, you'd agree with me, Mr. Strother, a person can own more than one piece of property under DCAD, and they would be listed as an owner, correct?
Yeah, I think so.
Okay. And just so we're real clear about this, and it's the position that you've already told us, I guess, is the position of Couture Hotel Corporations. We'll get to that in a second. Let's move. I'll come back to this. So 6 attempts were made during that time. And then we go to the next exhibit 2, which is Mr. Conley's declaration. And there were 5 other attempts, were there not? November 26th, November 27th, November 30th, December 4th, and December 7th by Mr. Conley to attempt service at the 3840 Innisbrook Drive address, correct?
That's correct.
And you'd agree then it looks like this attempt to serve Mr. Patel continued, I guess, on your request?
Yes.
Okay. Despite that you thought you already had service, correct?
Yes.
Okay. And let's go through these entries. On November 26, 2019, there was no answer at the door and no vehicles present, correct?
That's accurate.
On November 27, 2019 at 2:20 p.m., again, there was no answer or vehicles, correct?
Yeah, I think he uses those exact words in addition to other language in all of these entries.
So fair to say, every time Mr. Conley went out there, he denoted no vehicles being present, correct?
Among other things, yes.
Okay. Anything within Mr. Conley's declaration where he indicates that 3840 Innisbrook Drive, Irving, Dallas County, Texas, 75038 is the residence or home of Mr. Patel?
No.
Going back to Miss Davis's declaration, Exhibit 1 to Exhibit 4. On November 14, 2019, it appears Mr. Patel told Miss Davis that your office could call him if they wished. Is that correct?
That's correct.
Did you or anyone from your office ever attempt to call Mr. Patel in November or December of 2019?
Honestly, I have no record of that happening.
Okay.
It's
Now I
possible.
want, okay, wait a minute. Anything's possible. Do you have a specific recollection of you or anyone in your office trying to call Mr. Patel?
Yes, just not necessarily in response to that.
In November and December of 2019, you have a recollection of that?
Would have been earlier, I think, during the initial suit filing.
So before November and December of 2019?
Right,
So before he offered for your office to call him, correct?
right.
Now I want to go to this again, the plaintiff's motion for substituted service. This is Exhibit 4 that we've been looking at. And this is paragraph 7. This is again a filing made by you, was it not, sir?
Again, yes.
And you understand under the Texas Rules of Civil Procedure, under Rule 13, when you file a document with a court, present it to a court, it's to be made in good faith, is it not?
I'm under oath, and I don't remember the wording of Rule 13, but I know when an attorney signs a document and files with the court, they better be believing it. Absolutely.
And it better be based on some type of reasonable inquiry, not be groundless, correct?
I mean, I don't remember. I'm under oath. I don't remember what Rule
Okay.
13 says, but my general practice would be absolutely.
Okay. Let's go to paragraph 7. This is what is written in this document for motion for substituted service. You write, the address that plaintiff has been attempting to serve defendant at 3840 Innisbrook Drive, Irving, Texas, 75038- is the home address provided by defendant in the bank records he circulated during the events underlying this suit. Then you write, that address has subsequently been confirmed by process server Davis, who spoke with defendant at that address. That's what you wrote, correct?
Yes, thank you for showing me that. Yes.
Okay, so let's go to the first sentence. I want to be real clear about that. So when you presented this document to the court, in order for the court to agree to substituted service, you wrote, and this is what you wrote, you didn't add anything else. You said the address that plaintiff has been attempting to serve defendant at 3840 Innisbrook Drive, Irving, Texas, 75038 is the home address provided by defendant in the bank records he circulated during the events underlying this lawsuit. That's what you put in there, and that's what you wanted the court to rely on, correct?
Yeah, you've asked me that a few times, so I object
All
to
right, well,
ask.
it's pretty important. The
I
bank
object to ask and answer.
Sustained. Let's move on.
The bank records that you present or you referenced here in paragraph 7, sir, I've looked through all the documents, and the only bank record that I could come across with regard to the funding that was to be made by Mr. Patel in this case was, and this is one of your documents, sir, defense exhibit number, and we subsequently numbered them for the court, so it's 42. Is this the document you're referencing?
And the motion for substitute service?
Yes, sir.
Can you blow it up a little more so I can take a quick look?
Let me get
I mean,
out.
just so I can see the bottom and top, if you don't mind.
I'm gonna just do it again. I don't know why I didn't blow up completely. Sometimes it's weird.
Matt, if you press the X on the comments, the 2 comments, there's an X right next to that.
Oh yeah. Okay, perfect.
Press
There we
that.
go.
There you go.
Thank you.
If you don't mind, Mr. Noah, just let me see the bottom real fast. Okay, I've got it. And the question is, was this the one I was referring to in the motion for substitute service?
Yes.
Yes, it is. Yes, it is.
Okay. Just so for the court to see this, this is the exhibit then that you were relying in which you told the court this was the home address of Mr. Patel, correct?
To be precise, I put in the motion that this was the bank record he circulated as part of the facts in the underlying lawsuit that indicate what his home address was. Yes.
Okay. And let's be real clear. Within this document, Mr. Strother, is my client's name, Jagdish Kumar Patel, even listed anywhere within this document?
No.
Within this document, sir, is there any reference that 3840 Innisbrook Drive, North Irving, Texas, 75038 is denoted as the home address of Jagdish Kumar Patel? Is it anywhere noted as the home address?
I don't see anywhere in here where it says this is anyone's home address other than it's the addressee for the personal bank account. So, but it doesn't use those words, I grant you.
Okay. And anywhere within this document, does it say it's his Mr. Jagdish Kumar Patel's residence?
That's what I'm just saying. No, other than it being an address on a personal bank account.
Okay.
It
And it
doesn't
doesn't
use
even,
the words residence.
I guess I can't see that Asha Ben Patel, that is not the same name as the
correct.
plaintiff in this case. It's somebody
That's
else.
correct.
Okay.
That is not, Jagdish Kumar Patel is not Asha Ben Patel, correct?
That's his spouse. It's not Jay.
Okay. And so, but when you presented this to the court, and you keep calling him Jay, I just want to make sure you don't know what his legal name is.
No, no.
Okay. Okay.
I mean, I've seen like he signs Jagdish. I've seen Jay. I don't know. He appears to go by
Okay.
several.
Well, hang on. I want to be real clear on this. You're telling the court you've seen documents where Mr. Patel signs his name as Jay instead of Jagdish or Jagdish Kumar?
I believe. Wait, absolutely. He's signed Jagdish. I could find you those right now.
That's I'm not,
Pardon me.
I'm not
I
arguing
think-
with you. My question was, have you seen documents where he signs his name as Jay versus Jagdish or Jagdish Kumar Patel?
I believe I've seen him sign J, like the letter J.
Okay. And have you seen documents where he signs it Jagdish, correct?
Yes, I've seen him
Okay.
sign a document with the 7-letter name Jagdish.
Okay. Have you ever seen a document where he signed Jay Patel?
As I sit here right now, I think I've seen him sign a document where his name is written as J, and then he signs with the letter J. But which, by the way, is what I do with Justin. I just haven't seen Jay written out in handwriting, I don't think.
Okay. So when you presented this to the court, I want to go back to what you wrote in paragraph 7.
Wrong exhibit.
I'll get there. Exhibit 4. You wrote the address that plaintiff has been attempting to serve defendant 3840 Innisbrook Drive, Irving, Texas 75038 is the home address provided by defendant in the bank records he circulated during the events underlying this suit. That is not an accurate statement based off the bank record we just saw, is it, sir?
I disagree. I think it is accurate.
Okay. And you've already agreed with me, nowhere within that document did it list home or resident, correct?
Didn't use those words. That's true.
Okay. And you also already agreed and told this court that Jagdish Kumar or Jay is not listed within that document whatsoever, correct?
I don't remember what your question was, but yes, his name does not appear on the bank record. It has his wife's name.
Okay. So that first statement, you're still going to, I'll strike that. Let's go to the next statement. That address has subsequently been confirmed by process server Davis, who spoke with defendant at that address. That's what you wrote, correct?
Yes.
Okay, and let's be real clear about this because this is going to be presented in the bill of review. At your sworn deposition testimony, sir, as the corporate representative of Couture Hotel Corporation, you told under oath that you did not believe that the conversation had occurred at that address. That's what you told us. We've already went through it, correct? Now you've changed.
False. What I said was it was unclear to me where they had the conversation.
Okay.
Now that I look at this, in fact, I now have my memory refreshed that a process server Davis did speak with him at that address. So
Okay.
I smiled when you showed it to me because I now have no, absolutely. She spoke to him. I'm 100% certain at this point.
Okay, and the whole
Now,
objection non-responsive. I just want to make sure that we're clear on the record and the court has this because this is important. The second sentence that you wrote to the court that the address has subsequently been confirmed by process server Davis, who spoke with the defendant at that address, is based solely upon this declaration marked as Exhibit 1, correct?
I'm sorry, I didn't understand.
Sure. Let me
Good question.
rephrase again, Mr. Strother. The statement here, the second sentence under paragraph 7, That address has subsequently been confirmed by process server Davis, who spoke with defendant at that address. That's what you wrote. That is solely based off of this declaration. That's what you're telling the court.
No, that's what I'm telling you is I'm really grateful that you showed me this because I recall now what the story is and why there was another whole attempt by a different process server. And it hinges upon Miss Davis's note there, which is that I didn't know to drop serve. My recollection is now that we did talk with Miss Davis. She apologized and put me in touch with the Easy Serve, the process serving company, who apologized and said that they were going to comp it and have another process server go out there. So yeah, I do recall speaking with Miss Davis. She did tell me that it was at 3840 Innsbruck.
Judge, I'm going to object. I got to object to non-responsive. I got to object to now hearsay. And now the witness has now just changed the testimony to say now he does recall, because I asked him about 30 minutes ago, did he have any discussions with Miss Davis? And he said he did not recall. Now he's saying he does recall. So I'm going to object to any hearsay statements by Miss Davis as hearsay. She is deceased now, so he's adding that testimony in. I'm going to put that part of the record.
Overruled.
Well, Mr. Strother, at the time of your deposition, you did not reference at all, and I want to be clear on this because you're presenting things to a court to be signed. Now you're telling us under oath that you did talk to Miss Davis after this service attempts.
Well, wait. Yes, when I say me, it could have been my assistant, Joanna, at the time. I'm telling you, I remember us, my office, talking with Miss Davis. That led to all of this. Absolutely. I now remember that.
Well, I'm object to non-responsive. I want to be clear on this so we have a clean record. It's your testimony, Mr. Strother, as you sit here then. You can't tell us if it was you who spoke with Miss Davis or someone else from your office. Is that fair?
That's fair.
Okay. So any statements that you had with Miss Davis concerning this process, service of process of Mr. Battelle, may have not been with you personally, but with somebody else at your office. Is that a fair statement?
Objection asked and answered.
Is that a fair statement?
Named.
Well, I guess, Mr. Strother, then who from your office spoke with Miss Davis?
Like I said, it was either me or my assistant at the time, Joanna.
And you just don't recall?
No, I recall getting the information, and I recall the process server company comping this service attempt and assigning a new process server, which hinges on Miss Davis's last comment here about she didn't know to drop the documents at his feet when she first went out there. So I now remember, and it's all making a lot more sense to me. I just don't remember if it was Joanna or me who spoke with Miss Davis.
Let's just be clear, Mr. Strother, when you were giving your sworn deposition, this information you're talking about, the conversations with Miss Davis or someone from your office, that was not presented at that time. Is that fair?
It wasn't asked at that time, but I didn't know. Like I said, I didn't realize it at the time. It was you showing me this other exhibit, with my statement and the motion for substitute service that prompted my memory. I'd forgotten that.
Well, I just want to be clear then. Is it your sworn testimony as the corporate representative for Couture Hotel Corporation then that Miss Davis told you or someone from your office that the 3840 Innisbrook Drive address was the home or residence of Mr. Battelle?
Not exactly. My testimony is that she told us that that's where she went out to meet him at 3840 Innisbrook. My assertion about it being his home hinges upon our independent research and Miss Davis saying that it was listed as the owner there.
Okay. So,
and of course, the absence of another address in there and him saying I'm on vacation rather than that's not my house, right?
Yeah.
So there's a lot that went into it.
I know a lot of this is being brought up for the first time, so I need to make sure I'm clear, Mr. Strother, on what you're saying. So is it a fair statement then no one from your office, either you or anyone else, had a conversation with Miss Davis in which Miss Davis told you or someone else from your office that 3840 Innisbrook Drive, Irving, Texas, 75038 was the home address or residence of Mr. Battelle? Is that a fair statement?
I cannot tell you that she said that that was his home during a phone call. True.
Or at any time with your office, did Miss Davis ever tell you that 3840 Innisbrook Drive, Irving, Texas, 75038 was Mr. Battelle's home address?
I don't think that's a fair question because you're wanting me to use your precise words, home address or residence, when there's a whole bevy of evidence that shows that she thought and we thought it was his home residence, and he wasn't telling her. So, like,
Judge,
no,
I'm
I will say over and over.
Judge, I'm objecting non-responsive. I'm going to ask him the questions, the basis for this, but I got to get the answers that, did she tell him it was a home or resident address? That's my question.
Overruled.
Mr. Strother, I think you agree with me that she never used the word home or residence with you at any time. Fair for 3840 Innisbrook Drive, but there's other bases that you're coming to that conclusion. Is that fair?
Like I said a moment ago, it's entirely possible that she used those words during the phone call. That's not a detail I remember. My memory is prompted by what you just have in front of me, where she said that's where she went and met him. Our contention about being his home address comes from other places other than my memory of a phone call with Miss Davis.
Okay.
Judge, is it possible to take 5 for just a minute? We've been on for an hour and 40 minutes.
Sure. Let's take a
I'm
break.
sorry, I just need to use the restroom and take a breath for a minute.
That's fine. No worries.
5 minutes?
Yep.
Thank you.